Thank you, Mr. Chairman. I appreciate the honor of being able to be here by WebEx. I wish I could be there in person. I am an attorney, been in practice since 1976. In areas of Article 5 background, I represented 4 Washington state legislators in the late 70s on into the early 80s in a case involving the ratification of the Equal Rights Amendment when Congress tried to change the rules for the deadline for ratification, expanding the deadline from 7 years to approximately 10 and a half years. I was in that case all the way to the Supreme Court, and so I'm one of the few lawyers who've actually litigated in the Article 5 area. I've also written an article concerning the whole issue of whether or not the original Constitutional Convention in Philadelphia in 1787 was a runaway, and that article is published in the Harvard Journal of Law and Public Policy. It's called Defying Convention Wisdom, and I'll talk about the substance of that real briefly in just a minute. The reason that Article 5 was written the way it is because of a suggestion that George Mason made in the last week of the Constitutional Convention. Up until that time, the proposed Constitution had only one method of proposing amendments. Congress had to propose all amendments, the states had to ratify all amendments. But Mason stood up and said, in effect, there's going to be a day when Congress abuses its power. When the federal government abuses its power, we can never expect Congress to propose amendments limiting its own power. We need to give the ability to limit the power of the federal government through proposed amendments. And the minutes of the Constitutional Convention say that his recommendation was agreed to nem com, which means without debate. And so it was unanimously agreed to by the founders. The founders gave states the authority to rein in abuse of power by the federal government. And with the authority that comes to you directly from Article 5 of the U.S. Constitution, I contend that the state legislators have the moral responsibility to do so. My wife and I have 10 children. I know that's an astonishing revelation, but it's true. So I've raised a lot of kids. If you had a child grow up for a long time and never discipline them, it would not be a very pretty picture. And the same thing is true of what we're dealing with here. Congress and the federal government have been expanding and abusing their power for decades upon decades, and the states have never used their authority under Article 5 to rein them in. For example, in December of this last year, there was a package of legislation, $1.7 trillion in spending, thousands of pages, hundreds of both spending and non-spending measures jammed together in one bill. If there was a single subject rule in the federal Constitution, like there is in 41 states, they couldn't do this. And this massive abuse of spending power and regulatory power would not be possible. If they had to break that all up, first of all, you couldn't get floor time for all that conglomeration. And secondly, a number of those things would never pass. So one of the procedural changes that could be made and would be germane under the application that we've proposed would be a single subject rule. And I think it would have a great deal of cleaning up the federal government's legislative process. I would be glad to answer the question that was posed to the code reviser about changing the subject. There have been hundreds and hundreds of Article 5 applications over the years. More than 34 states have existing valid applications, but they're not on the same subject. And the reason that we've never had a convention is they have to be on the same subject. You can't change the rules in the middle of the stream. That's what the Article 5 litigation that I was involved with the ERA said. You can't change the rules in the middle of the stream. When there's a call for a convention for a particular purpose, it's limited to that purpose. There's another historical example. The Articles of Confederation were tried. There was an effort to change them twice. First was the Annapolis Convention, where they were limited only to the subject of commerce. The delegates got together and said, commerce isn't a big enough area of discussion for us. We need to have authority to talk about more topics. And so they said, we've got to go back to our states and get a new resolution urging that we have a broader mandate to talk about things. They didn't run away. They went back and got a different authority. And the new authority said that they were to render the federal Constitution adequate for the exigencies of the Union. And so that's the background, and there's no way that this can be violated. And if there is, I guarantee you, I will file the lawsuit myself, just like I did with the ERA. I was the first one to file the lawsuit challenging that misuse of the rules of the Article 5 process. We were successful then, and I'm confident we would be successful now. With that background, I'd be glad to answer any questions that the committee might have. I was the draftsman of the operative language of the text in front of you, and it's been passed verbatim in that form in 19 states, and we're hoping that your fine state of Kansas will be the 20th state.
Very good, Michael. Thank you for that. Committee questions of Michael? Seeing none, thank you for being here. Oh, sorry. Representative Hauser.
Hit the button. Thank you, Mr. Chair. Thank you for your testimony, Mr. Farris. I got a question for you. Can you guys, who controls the purse strings of the federal government?
Well, it's the House of Representatives. All revenue measures must begin in the House of Representatives. Then ultimately the Senate and the President get involved because all three branches have to be involved, or, a bill has to pass both branches and be signed by the President. But so in a broad sense, in a legislative sense, it's the entire congressional process.
Could you show some kind of, I want to say, proof of your, well, let me just ask you this question. How actively do you guys, the Convention of States movement, petition our congressmen to actually balance the budget because they control the purse strings? Can you say that? Can you show me anything that says that you try to get your followers to petition the Congress to control their spending and go that route instead of just trying to open up the Constitution again?
Well, first of all, the premise of your question isn't accurate. We aren't opening up the Constitution by proposing amendments any more than Congress is opening up the Constitution when it proposes discrete amendments. If you will, Congress has the authority to propose amendments every single day. So if the Constitution's open in that sense, it's open every day when Congress is in session. But millions and millions of Americans have urged Congress to balance the budget. President Reagan ran urging a balanced budget amendment to the Constitution. He thought that amendment was necessary in order to put discipline on Congress, and Congress simply has never done so. So have we done that? No, because it would be an exercise in frustration, because millions of Americans have been doing this for decades upon decades, and it's time to bring some restraint upon them that's structural in nature, because even if they balance the budget one year, that doesn't mean they'll balance it the following year. Until there's structural changes, it's not going to happen on a consistent basis.